Hey guys, you don't settle. Nnamdi Kanu moves to appeal court challenging Justice Nyako's jurisdiction's ruling. Welcome back to Prospect Channel TV. Thank you for always coming out here. If you're just joining us, please kindly subscribe and don't forget to give us a thumbs up. The leader of the indigenous people of Biafra, IPOB Nnamdi Kanu, on Tuesday headed to the Abuja division of the Appeal Court over the decision of the Abuja Federal High Court, refusing his application, challenging the court jurisdiction to entertain his trial. On June 19, Kanu had filed an application challenging Justice Binta Nyako led Federal High Court decision to entertain his trial. However, Kanu, through his late counsel, Aloy Nyako, filed a notice of appeal before the Abuja Appeal Court over Justice Binta Nyako's ruling. In the notice filed before the court, Nyako said Justice Nyako reread in law, held in law, and occasioned grave miscarriage of justice against Nnamdi Kanu, when she said the main claim in this application deals with the count of charge the defendant is facing. This count of charge that this court had retained after a considered ruling on the court of charge dismissing 8 of the original counts. The main issue is that if the defendant has a problem with the court of charge retained, the option open his appeal. According to Nyako, earlier today, I filed a notice of appeal with the Court of Appeal in Abuja against the 19th June 2024 ruling of Justice Binta Nyako, refusing Mazi Nnamdi Kanu's application challenging the jurisdiction of the Federal High Court to subject him to trial. Nyako said the trial court held in law when it considered only one out of the 7 jurisdictional grounds raised in the preliminary objection and the lone ground bordering on the repeal of the Terrorism Prevention Amendment Act 2023, occasioned a grave miscarriage of justice against the applicant. He said the Leonard trial judge held in law and thus occasioned grave miscarriage of justice against the applicant when the trial court refused the preliminary objection even after it held that all the arguments of counsel may be correct, but it will require the court to take evidence before it can pronounce on the argument. The trial court was right to hold that the argument of the counsel to applicants is well founded or may be correct, but the Honorable Trial Court held and or otherwise misdirected itself on the law when it held at the same time that the said argument will require evidence before the trial court can make its pronouncement. The Leonard trial court held in law when the court ignored the glaring fact that respondent failed woefully to contradict or deny the affidavit evidence of the applicants and even admitted to some of the dispositions of the applicant. The Leonard trial judge held in law and occasioned grave miscarriage of justice against applicants when the trial court held that the notice of preliminary objection was an abuse of judiciary process and consequently struck it out. So as you can see, this battle seems not to end soon, but though the last hearing, Binta Nyako, invoked the federal government and Nnamdi Kanu to seek for reconciliation. They should settle out of court. You understand? Meanwhile, Nigerians are still appealing to President Bola Ahmed Tinubu to release Nnamdi Kanu, just like what he did to others. You understand? Nnamdi Kanu's case should not be exceptional, because it's not looking like the Igbos are marginalized, or can I say they are they are marginalized with what they are saying. So that means what Igbos are saying about marginalization in Nigeria is correct. If the federal government of Nigeria could release those people with the same charge, but Nnamdi Kanu still in DSS custody, and the AGF telling Nigerians that Nnamdi Kanu's case is a difficult one, that only the court, can determine his fate. So that means something is wrong. Well, I'm dropping it here, guys. Kindly drop your comments below the comment section. Don't forget to give us a thumbs up. Share this video, let it go viral. Thank you and bye for now.